Welcome, everybody. We're excited to have you in class today. My name is Kerry Sautner. I'm the Chief Learning Officer at the National Constitution Center, and I'm here with one of our top scholars, Tom Donnelly. So today we are going to dive deep into the Second Amendment, look at the amendment directly, and then kind of explore it in different time periods and how the amendment was understood and used by people, and how do we understand it today, and what are the current cases around the Second Amendment today that we're debating, and a lot that we have to, as Tom said earlier, if you were here, to stay tuned for, to really kind of define how the courts are going to read the Second Amendment. So Tom, so much to dive into. And you know, I always start with a million questions for you as we go into these areas, but it really does start with, you know, the beginning. And why did the founding generation put the Second Amendment or add the Second Amendment to the Constitution in the Bill of Rights? And kind of, why don't you set the stage for us? You know, of course, say hi to all the students. They're excited to see you, but also set the stage for us of kind of what is the big constitutional question that we're going to grapple with today.
Well, that sounds good. That's great, Kerry. And so the big question here really is, you know, we have the Second Amendment in the Constitution. It's dealing with the right to keep and bear arms. And the big question for us is that when can the government limit the individual right to possess guns and other firearms, and when can't it? So this is the key, this is the central constitutional question. And as always, Kerry, should we start with the Constitution's text?
I think it's great. And, you know, really important for this one, because this feels almost like an English lesson, not just a constitutional law lesson to me.
Yeah, and I mean, it's among the most famous texts in the Constitution. There's no doubt about that. But just to, let's read it together, and let's really then parse the two main clauses. So here are the words of the Second Amendment: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so when we're looking at this text, we're going to divide it in half, much the way that Kerry did there, because a lot of the debates here, the constitutional debates over the Second Amendment, are over the relationship between these two parts of the amendment. So let's begin with that first clause. Now, lawyers, the fancy word for this, they often call it the Prefatory clause, but it's really just that first clause that Kerry has highlighted on the screen right now: a well-regulated militia being necessary to the security of a free state. And so one way to understand this clause is its connection to the founding generation's vision for the amendment. So what was the founding generation concerned about? They were concerned about the threat of standing armies. So these are professional armies paid for by the government. They're established, permanent. And for the founding generation, when they thought professional army, they thought of, you know, people who are somehow disconnected from their communities. Maybe they don't have families. That's why they're willing to be join a professional army, be paid for by the government. And history for the founding generation suggested to them that these standing armies could often be associated with tyranny, that they were a way to abuse people's rights, that they were a threat to our liberties. And so with this initial clause here of the Second Amendment, it recognizes that the founding generation really valued the citizen soldier. So the citizen militia. And these are militias that are organized by state and local governments, that are led by local community leaders, that are comprised of members of the local community. And the idea being that we in America, we're not going to just rely on some sort of professional army that's distant from we, the people. Instead, we're going to defend ourselves. And that's a core part of our duty as citizens. So that's the first part of the clause of the Second Amendment. The second clause here, lawyers call it the Operative clause, but in many ways, it's talking about a core right. And so here the language is: the right of the people to keep and bear arms shall not be infringed. And so if the first part of the amendment really is about sort of that central purpose of the founding generation, that we need a well-regulated militia to secure our free state, this second part is about some sort of, you know, broader right that exists. And so the question here ends up being, do we read these two? So there are two ways in which scholars and even justices read this amendment. One is to say, well, the first clause, that clause about a well-regulated militia, it should in a certain way limit how we read the second clause. So what is the Second Amendment really about? In that case, it's really about having the right to keep and bear arms connected to that vision of the citizen militia. And so with this, we may say that that citizen militia vision isn't as relevant today. And so maybe the Second Amendment should be read fairly narrowly when we have challenges to gun regulations. But other scholars, other justices argue, no. The best reading of this particular amendment is that the really important clause is that second one, that operative clause. Speaking of an individual right to keep and bear arms, that this speaks to a pre-constitutional natural right, one that existed before the Constitution, one that the founding generation wanted to write into the Constitution that's broad, that in part what it does is it ensures that a citizen militia exists, but it's also something that's broader than that. It's connected to a broader right to self-defense. And so that's sort of the constitutional debate. Kerry, I'll pause there.
And, I think that's so great spelling it out that way. And we know how we're going to talk about how some of the more current cases have discussed this and defined it. But I think that is so much of the conversation that our students hear every day, that you hear one side or the other. And it's depending on, like you said, justices read it both ways, some one way, some the other. But when we think about the big question that we're going to grapple with through these cases, is when can the government limit an individual's right to possess guns or other firearms, and when can it not? So that's our big constitutional question. Now, I wanted to dive into the history and kind of why were we so worried about a standing army? Because when you read some of the founding documents and the Federalist Papers, you hear that over and over again. They're like super worried about it. Not everybody, but a lot of people. And then one other side question for you, Tom, as I think about this, would you consider a citizen militia similar to like a police force today, that it's people in the community that are organized, and maybe a police force could grow out of a citizen militia, or is there no kind of connection between the two?
Yeah, I think there are some similarities, Kerry. I mean, I think the one thing to keep in mind, what was the citizen militia for the founding generation? There are two parts of it. One is that they really are connected to state and local government. They're not just some rogue agents. They're really connected to the government in that way. But also the citizen militia is quite broad. It's able-bodied people in the community have this duty to serve in a militia. So it's not just some subset of people taking it up as a profession, but it's part of our broader duty as citizens in the community and eventually, in the broader nation.
Do we have something like that today, or is this something that was just from different time periods?
I think the analogy would be what we've done effectively is we do have sort of like the different state guards in state by state. And so we've lost that sense of all of us having a duty to serve the community, but we still do have the idea of there being this government force that's there, that's organized by the government, that's meant to in part ensure our security.
That's really helpful. I just wanted to give students kind of like, what does it look like kinda today? Okay, yes. So why are they so worried about this standing army? Like, I mean, you look at it, it does look pretty powerful, pretty organized, and, very uniform, no pun intended. But like, why are they so worried about it? What's the experience of the colonists that make them have a good worry about a standing army?
Yeah, so I mean, the initial context we'd want to go to here is back to colonial America and to Boston. And so this experience here of having a British army in the colonies. And so for the founding generation here, we had British troops on American shores in the 1770s. And to the American colonists, this felt like sort of an imperial occupying force of sorts. So if you're a member of the colonies and say you're in Boston, you've already had the British Empire suspend local government for you. And now they send in all of these British troops to occupy Boston. And it's a lot of troops. I mean, Boston itself is not a big city at the time. So if you're talking about sort of in the 1770s, it's roughly 16,000 people. Well, the British by 1775 send 4,000 British troops to occupy Boston. So it felt like this pervasive force, both on the streets, but also because of the quartering acts, sometimes in colonist homes. And so this experience here during the American Revolution ends up coloring the American colonists' views about standing armies. They became suspicious of them. They became fearful of them. They felt like a force that could really, really threaten our liberties. And how do we know this? Well, just look at the Declaration of Independence. When we're talking about the different things, our different grievances against King George and Great Britain, here's one of them, that King George kept among us in times of peace standing armies without the consent of our legislatures. So part of it is this colonial experience. But of course, we also know that for the founding generation, they were students of history, many of them. Certainly James Madison was, the primary author of the Bill of Rights, including the Second Amendment. And so when they're looking at history as well, they look at professional armies like the British Army as bodies that can't be trusted. Because if you look at history, if you look at Europe and monarchies and despotism there, what do they have? They have standing armies. And these standing armies over time are used to abuse the rights of the people. They're used to keep those in power, and they're often disconnected then from the people themselves. And so with this, in America, the vision becomes, and this is as we get into the Constitutional Convention, as we get into the Bill of Rights, the vision here, at least in part, is one, many of us, even those of us who support the Constitution and a stronger national government, we are fearful of the dangers of a professional army. And so certainly the anti-federalists, those who oppose the Constitution, concerned about standing armies was a core concern that they had about this new government, that this new government had new powers to raise an army and have a professional army just like the ones that they feared from the colonial experience and from history. But that part of it too is that can't we in America, can't we do it differently? We are a government of the people, by the people, for the people, as President Lincoln said. And part of this is that can't we organize citizen militias to keep us safe? Can't we connect this to America, what it is to be an American, to have a duty to defend your community? And can't we then, because of that, say, if we, the citizens, take up this cause, can't we then say, national government, we don't need a large professional army? And so as we're coming out of the American Revolution, the founding generation is really trying to weigh two big lessons here. One is the lesson of the dangers of a standing army and the ways in which that threatens our liberties. But the other thing to remember, though, Kerry, is what else did they learn from the American Revolution? The Articles of Confederation, that national government that existed during the Revolution, that we fought the Revolution under, was pretty lousy in many ways. It was weak. One of its weaknesses was precisely that it couldn't really raise a fighting force to keep us safe. We won the American Revolution. That's great. But looking forward, if you were among those in support of a stronger national government now, say George Washington or Alexander Hamilton, who played a key role in the Revolution, they look at that old government and they say, one, it did not have enough power to keep us safe, so national security being a key part of the new Constitution. And two, maybe we do need a standing army sometimes to reinforce us and to keep us safe. And so we see this. Oh, I'm sorry, Kerry. I see you want to hop in.
I just was like laughing because isn't it pretty true that we win the revolution because France let us borrow their standing army?
It helped.
Like, I just think it's like, I get it. They're trying to balance. They're really worried about a standing army because then a government that becomes too powerful can use it to oppress people. So I get that, like, one worry. But on the other hand, they have already seen in the war, but even after the war, with little mini insurrections that bubble up, that they need a standing army to protect the people as well, or need a more organized way to take care of them, not just internally, but externally as well. The British really haven't left. The Spanish are still kind of closing our ports as well. So there's a lot going on here, and they're trying to balance a fear and a need at the same time. But it did make me laugh that France's standing army was totally fine to borrow.
Well, and the thing is, with the new Constitution, we respond to that in two ways, Kerry. One is that we give Congress new powers to both regulate the militia. So they have some powers to both regulate and discipline the militia, some power to call the militia forth to help put down troubles that we may see at home or to repel invasions from abroad, but also new powers to raise an army. And so they do have powers to create a professional army, precisely the ones like the many of the colonists feared. And so there are these new powers in the Constitution over national security, allowing them to raise an army, allowing them to regulate the militia in certain ways. And so you have critics of the Constitution, first at the Constitutional Convention. So our three dissenters, those three delegates who refused to sign the Constitution at the end of the convention, George Mason, Elbridge Gerry, Edmund Randolph, one of their big arguments is, don't we need some sort of text in here in the Constitution limiting this new government's power to create a standing army in times of peace? Isn't that the lesson of the American Revolution? Isn't that the lesson of history? Shouldn't we heed it here? And then as we get into the ratification debates, these battles between the Federalists in support of the new Constitution and the Anti-Federalists opposed to them, one of the arguments they have is precisely over this question of what of the new government's power over national security, over a professional army, and over the state militias. And so, the two sides, the Anti-Federalists basically echo the arguments we've already talked about, which is that this new national government has too much power. It can, maybe it's going to use its power. It has this new power to regulate militias. Maybe it's going to disarm our people Maybe it's going to use that regulatory power to disarm our people, and maybe it's going to use its new power to raise armies to create a massive army that can threaten our liberties. So these concerns are really central to those who oppose the Constitution. And the flip side being, you have arguments from key Federalist supporters of the Constitution, Alexander Hamilton and James Madison, saying, no, the standing armies are important to our national security over time. Hamilton making the forceful argument basically that you anti-federalists have to grow up. If you want a real government, part of that is that you need a professional army. That's how we're going to remain safe over time. And we are building a Republican government where if you don't like what the national government's doing, then throw those elected officials out because they are the ones that are going to be controlling the military. And James Madison sort of strikes a balance, Kerry, of sort of saying, yeah, exactly. On the one hand, yes, Alexander, my good friend, standing armies are useful. That's definitely true. But we in America are trying to do something different. Citizen militias are still really important for all of the reasons that the anti-federalists are saying. So let's have a system where we can have a balance of both of those things. And so with the Constitution and the Second Amendment, what do we get? Well, we get a new Constitution that really does have new and broad powers over, which allows the new government to raise a professional army and also to regulate the militia. But we also write in the Second Amendment something that responds to the anti-federalist fears and says that no, I mean, part of this, the core of the Second Amendment is saying that you, national government, cannot disarm the people who are central to this vision of citizen militias helping to keep us safe and helping to keep our nation free.
Awesome. So as we kind of like think about the Bill of Rights and the Constitution as two sides of that debate, and I love that kind of juxtaposition that the Constitution gives power to the federal government to have an army, but at the same time, the individual right and the citizen militia right is in the Second Amendment with that Bill of Rights, that listing of rights for the people. So thinking about those in two ways and trying to understand what their worry was at that time. They're worried about this big, all-powerful national government oppressing the people. Things change 100 years later. And when we think about where's the worry and where is the balance, it shifts after the Civil War. So how does this conversation change with in 1865, let me get the year right, 1865, the onset of the Civil War, the movement of Union troops into the South after the Civil War, and then the Reconstruction time period when the Union troops move away?
Yeah, I mean, that's a great way to phrase it and frame it there, Kerry, because one way to think about the Second Amendment and how these two founding moments matter is about what is the central evil that those key figures, the key drafters and ratifiers of provisions of our Constitution care most about. For the founding generation, it was a concern about a newly powerful national government, professional armies, and the ability of that new national government and their army to oppress the people. But with the Civil War, we see a paradigm shift of sorts. We see a real shift in focus in important ways. Because now, when we look at the national government, when we look at the army itself, it's not simply, or it's not really, it's not an agent of oppression, but in the Civil War, from the perspective of the victorious Republicans and African Americans, et cetera, the national government and the national army become agents of liberty. And states become, agents at times of insurrection, of threats to national security, of threats to union itself. And so there's it's not to say that suddenly after the Civil War and during Reconstruction, now it's, oh, the national government's great and it can do absolutely everything. Of course, we continue to battle over what goes to the national government, what goes to the states, how do we balance the national government's powers and states' powers. But there's at least a shift in the understanding of many Americans about what the national government can and ought to do and its relationship to our fundamental freedoms. And of course, part of this, Kerry, is the story of what happens after the Civil War. And so, in the early years, what we see is white Southerners in control of the governments. And one of the first acts that they do in these new governments after the Civil War, they pass the Black Codes. And these Black Codes are meant to place African Americans as much as possible back into a condition of slavery. And so what is one of the key provisions you see in these Black Codes? The white Southerners are saying, African Americans, we're going to take your guns. We are not going to honor your right to keep and bear arms. And of course, this is notable because some of the African Americans who they're attempting to disarm through the Black Codes, they were Union soldiers. They were ones who helped fight and win the Civil War. And so you see key figures like Frederick Douglass, like these series of conventions of African Americans all throughout the South, all saying that, one of the, really two big things here. One is we need the national government to protect our rights. Our state and local governments aren't doing it. We need the national government to do it. And what sort of rights do we want protected? Well, one of the big ones is the right to keep and bear arms. Why? We can't trust the state and local governments to keep us safe. They're the ones trying to disarm us. When we are in danger, we can't turn to them. We can only turn to ourselves. And that's precisely why the individual right to keep and bear arms is so important to the African American community after the Civil War. And we see this reflected then in their Republican allies in Congress. So the Republican Party at the time, it's the party of Lincoln, the party of Union, the party that won the Civil War. Well, and it's a party that's allied very closely with African Americans. Many Republicans are African Americans, but the ones in Congress at this time they're the ones that they're passing some of the first civil rights laws in American history. What are they doing through these laws? Things like the Civil Rights Act of 1866 and the Freedmen's Bureau Act. They're trying to protect the fundamental liberties of African Americans, one of those being the right to keep and bear arms. And, as they're drafting and eventually ratifying the 14th Amendment, they're talking about all the different protections they think, all the different freedoms that they think are essential to being a full American. And what their vision here being, what sort of rights do we need the national government to protect against state abuses? Because remember, the original Second Amendment, it only applied to the national government. It's through the 14th Amendment and later Supreme Court decisions that many key Bill of Rights protections apply to state abuses. And part of what the framers and ratifiers of the 14th Amendment are saying is that we need a new amendment that gives the national government and its courts the powers to protect some of our fundamental freedoms, most notably those that are written into the Bill of Rights. And what are the key rights that they want protected? They talk about things like free speech, but they also talk about things like the individual right to keep and bear arms. And so just to place to emphasize the bottom line here, Kerry, so what we see is sort of a newfound focus during this period of time on the centrality of the individual right to keep and bear arms to personal self-defense. And so we could already see sort of like a shift in the focus from the founding to the second founding, and the debates moving forward end up being, how do we read, what is the best way to read the Second Amendment's text in dialogue with this founding era history from the original founding, and then this history that we see during the Civil War, Reconstruction, and America's second founding.
And I think that's so fascinating. So when our students are trying to understand what is the meaning behind these words that we read in the Second Amendment, that they're looking at different time periods and the acts, and also the acts of Congress, but also all the work that's being done around it in the cases to try to define that. Now, we have about 7 minutes left, so I want to kind of bring us up to modern times. So we might jump a little, but I wanted to kind of tee up this question. Because it has a lot to do with what you were just talking about, personal security and self-defense that we saw in that Freedmen's Bureau Act. But the hypothetical is, can a city effectively ban handguns within the city limits? So can a city say, okay, I'm in Philadelphia, there are no handguns allowed in Philadelphia at all? That's the general. So students, if you want to kind of, we're going to go through a couple cases that get at the heart of this question and look at really what they're parsing out. But if you want to take a guess of where you think it came out in the courts, you can feel free to put that in the chat now. And the question is, can a city effectively ban handguns within the city limits? The two cases that we're going to look at is Heller and McDonald. And if you want to go to Milner, you can too, but the big ones that we'll look at. So we'll give the students a minute to answer in the chat. But Tom, if you want to start kind of laying out the storyline behind Heller, we can do that too.
Absolutely. And so one thing you'll note already, just looking at the dates of Heller and McDonald, the Heller case is 2008, McDonald is 2010. These are really the first big statements by the modern Supreme Court about the Second Amendment. It's just one of the extraordinary features of this part of the law is that the Supreme Court just said very, very, very little about the Second Amendment through most of its history. So our landmark cases are just a little over a decade old. So let's tick through them. I mean, the other thing to note, though, is that in both Heller and McDonald, that we see powerful opinions both in the majority and the dissent. Both of these cases end up splitting the justices 5-4. So we see justices really taking opposing sides on these constitutional issues. The issue in Heller is exactly the one that Kerry flagged in our hypothetical. It's the District of Columbia. So this is not, it's not a state, it's a federal territory, it's governed by federal law, so it's governed by the Second Amendment itself. And so the argument here for the challengers in Heller is that the District of Columbia's handgun ban violates the Second Amendment. It violates the right, the individual right to keep and bear arms that's written into the Second Amendment. And the dividing line between the justices is precisely the one that we flagged at the beginning of our class together today, which is how do we read the relationship between that first part of the Second Amendment and the second part of the Second Amendment. And so the majority and the dissent come up with different conclusions. And the last thing, Kerry, about these two opinions, both of them actually rely on very similar sources. So we would say, in legal parlance, they were both originalist opinions, which means it's a fancy way of saying that the opinions themselves focus closely on the amendment's text and then on the founding era context, so the founding era history. And so the majority, which is the majority opinion written by Justice Antonin Scalia, so this is for 5 of the justices, says that the best reading of the Second Amendment is an individual rights reading. And so if we're looking at those, maybe if you put the text back on the screen, Kerry, if we read sort of the two clauses of the Second Amendment together, what the majority is effectively saying is that the key part of the amendment is the second part. It's the right of the people to keep and bear arms shall not be infringed. And so if we're reading these two things together, we should read the first part of the amendment as stating just one of the most important purposes for that right. So we have this individual right to keep and bear arms. One of the central purposes is precisely so we can have a citizen militia. But what the majority says is that's not the only reason. That doesn't limit the right that's actually expressed in the amendment. And so the argument here, how does Justice Scalia reach this conclusion? Part of it is focusing closely on the text of the amendment itself. So looking at words like arms and phrases like bear arms, and looking at dictionaries from the time period in which the amendment was written and ratified, and also how those words were used in context and sources at the time. And what he says is that those are the sort of words that speak not just to military uses of firearms, but uses of firearms outside of that context. He also says that this particular amendment, we can't read it in a vacuum. We can't just read it as words out of context just on a page. We have to understand that founding era context. And part of what the founding generation believed in was that this individual right to keep and bear arms was a pre-constitutional natural right. It was also a right that they had as colonists, as English subjects, because it's a right that was part of the English common law and part of the English Bill of Rights. And so part of what they're trying to do with the Second Amendment is a lot like what the founding generation did with amendments like the First Amendment and free speech, which is to write in the Constitution cherished rights that pre-existed the Constitution are natural rights. And so Justice Scalia is saying that the Second Amendment is in part about enshrining that natural right, this broad right, into the Constitution. And then finally, he says, if what you're looking at here is what's the best way to read the Second Amendment, or a simpler way in like modern language, it might say something like, because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the conclusion here is that the District of Columbia handgun ban is unconstitutional. So the majority strikes it down as unconstitutional. And the big principle here behind the Second Amendment, they say, is that the Second Amendment at its core is about an individual right to keep and bear arms for self-defense inside one's home. And that precisely because handguns are so essential to that, a restrictive ban like what the District of Columbia has is unconstitutional. Now, the dissent here is authored by Justice John Paul Stevens. He himself takes a similar approach where he looks closely at the Constitution's text, the founding era history, but he reaches a different conclusion. What he says is, the best way to read these two clauses of the Second Amendment is to read them together and as closely connected. And so the right to keep and bear arms, the text itself suggests that it's closely connected to militia service. And that therefore the Second Amendment is really about the founding generation's concern about standing armies, about professional armies, and about the centrality of the citizen soldier to our protection going forward. It doesn't really speak to an individual right to keep and bear arms. And then finally, he says, part of the reason we know this and the reason why the history matters is that we know that James Madison wasn't just coming up with the Second Amendment off the top of his head. He had state constitutions in front of him. He had proposals from various ratifying conventions, and he had a choice to make when drafting it, as did the rest of the founding generation when deciding to approve of it. And that's to say they could have taken a text that clearly protected an individual right to keep and bear arms. For instance, the Pennsylvania state constitution at the time had something like that, but they chose one that really highlighted the importance of the militia. And because of that, we should read it accordingly. So for the dissent, the key bottom line is that the District of Columbia's handgun ban is constitutional. They upheld it. They said a law like that is permitted under the Second Amendment.
Now, when we look at the next case, which applies almost the same conversation, almost the same dialogue to all of the states, not just the District of Columbia, is it the same split too? I know it's 5-4, but is it the same people split exactly the same way?
It is.
Yeah. So, okay. So basically they just reapplied the same arguments to this case.
In part. So there is a dissent by Justice Breyer in this case where he does basically take on a lot of those arguments from Heller again. And in light of some additional scholarship that came out between Heller and McDonald's to try to say, no, we got Heller wrong. Let's get it right here. But McDonald here, so this is where the court has to take up the natural follow-up question. So Heller was about a law passed by the District of Columbia. This is a national law. The District of Columbia isn't a state. And so the Second Amendment itself applies in the District of Columbia. The question in McDonald versus City of Chicago was that, this question of whether or not the Bill of Rights, the Second Amendment, should extend to state abuses, to alleged state abuses. And so lawyers call this the question of incorporation, but it's really just a way of saying, do we use the 14th Amendment to apply the Second Amendment's right to keep and bear arms to state and local laws? And so again, here we have a handgun ban in the city of Chicago. It's very similar to the one in Heller. And so the question is basically, does the analysis in Heller apply now to the states, and in this case, to the city of Chicago's handgun ban? And what the court says, it divides 5-4. What the majority says, yes, the Second Amendment is incorporated against the states. The Second Amendment applies to state and local gun regulations. And as a result of that, we have to apply the same analysis that we had in Heller. And the city of Chicago's handgun ban, it has to fail too. The handgun ban in the city of Chicago is unconstitutional, and for the same reason as what we saw in District of Columbia v. Heller. And then the dissent, makes really two arguments. There's a dissent by Justice John Paul Stevens, which says, no, actually, the Second Amendment should not be incorporated against the states. It should be something that only applies to the national government and then to federal territories like the District of Columbia. And then we see a dissent by Justice Breyer saying, no, we have to look hard again at Heller itself and how we read the Second Amendment itself. We were wrong then. There's been new scholarship that suggests we were really wrong, and we should correct that now. But again, it's 5-4. The majority here says the handgun ban is unconstitutional and that the Second Amendment is incorporated against the states.
It's interesting. Breyer was trying to sneak in more evidence to the argument of why the original case shouldn't have went that way. So I find that fascinating, students. And we always encourage you. We know it's a lot of content, but we always look at what's the big question they were trying to answer and how did they split? Because it's 5 say the Second Amendment does apply to the states, and 4 say no. And why did they say no? So always you have to give your reasoning too. Now, as students, as you look at this hypothetical, we're going to leave you with is how does this conversation about handguns in the home for self-defense apply to a question that the court is going to be grappling with in the next year? And the hypothetical that is really the true thing that they're dealing with, it's not a hypothetical, is can a city pass a ban on carried and concealed firearms, allowing for the carrying of the handguns outside of the home if the citizen can show a special need for self-protection? So when they talk about carried and concealed, that's like putting it in your jacket so nobody else sees it, right, Tom?
Correct. And this is dealing with certain states that require someone to get a permit and state a special reason why they need to have that concealed weapon outside of the home.
So just as we kind of parse this out for the students, how much does it matter that it's hidden or not hidden? Is that a big difference when looking at the law?
It'll be hard to say exactly how they'll analyze it. I think the best way to think about it, Kerry, is, so just to back up quickly, what did Heller and McDonald decide? Well, it decided that, one, the best reading of the Second Amendment is an individual rights reading. so that there is an individual right to keep and bear arms. And what they said even beyond that is that the central purpose of the Second Amendment is a individual right to keep and bear arms for purposes of protecting yourself inside your home. And so this case then asks the natural follow-up question, which is whether or not Heller and McDonald travel outside the home. And so, and the last thing I'll say, though, is that Heller and McDonald leave a lot of questions, including this one, undecided. Because also within Heller itself, you see language there by the majority. So those who struck down the DC law acknowledging that there are existing gun regulations in the country and suggesting that Heller doesn't mean that they have to be declared unconstitutional. So Heller itself acknowledges that the Second Amendment, like every other amendment, the right in there, it's not absolute. And so a lot of the cases going forward are going to be parsing, when is it reasonable? When can what sort of gun regulations might be reasonable under the Second Amendment and which may be unreasonable? And the court has a lot of options as to how they want to read the right, whether it's a right that's going to end up striking down a lot of gun regulations or one that's going to be more limited. That's part of what that's part of what scholars continue to debate. And that's part of what the justices are going to debate in these various cases.
And I love the students are kind of try to break it down outside the home, self-protection, carried, concealed or not concealed, like looking at all those factors that play into these decisions. And we talked about this before. I always wonder, how do you prove that you need it? Like, what do you have to show for special need for self-protection? That seems a little arbitrary to me. And I would want to know more about how you actually can kind of spell that out. But I think it's really important for our students to kind of break this down and look at it. And you led the class with this, Tom, and I think it's so important that they're going to look at this case over the next year. And so as we kind of break it down as the constitutional class that we have together, we're also going to be saying, let's wait and see what the courts do say around this and how do we think they're going to go. And the students can play their own constitutional Supreme Court case game show in their houses and with their dinner tables too.
No, that's absolutely right, Kerry. And again, it's this moment in the Second Amendment is a lot like what people in the 1950s and especially 1960s felt around other Bill of Rights protections, where the court was filling out all of the different legal tests that are going to apply to things like the First Amendment's protection of free speech, et cetera. And so we're going to probably see similarly the development of the law, because again, the landmark cases are just over a decade old. So we're just at the beginning of this process of filling in what the contours of the Second Amendment right are going to be at the Supreme Court and in the courts throughout the country.
That's so amazing. And so students, thank you so much for joining us today. And remember kind of that big takeaway. This isn't just something that was written 233 years ago or 31 years ago, but it's something that we're understanding and defining in our own time, in this now and time. So talk about history being made right here. It's kind of cool, kind of interesting, and we get to be a part of the debate and discussion. Tom, thank you so much for class today. This is one of my favorites because it's so fascinating and I feel like I learn so much every time. Students, thank you so much for class today too. And any final words, Tom?
No, just the case we talked about, the hypothetical here, it'll be argued in the fall. And it's one of those big Supreme Court cases that probably won't be out until about a year from now, the actual decision itself. So we have plenty of time to dig into the arguments on all sides.
Awesome. Great. We'll have a whole year to dig deep and see where we land. And then we'll take bets and see what we end, who gets it right. Thank you much. Thank you very much, everyone. Have a great one. And Tom, I'll see you in an hour for next class.
Perfect. Thank you, Kerry. Thanks, everyone.